Did you enter the US without inspection? Or are you in a preference category and you have to leave the US in order to go to your visa interview? Then you must have heard about the I-601A waiver. In this video, we're going to talk about the 3 things you need to know, which are: what is an I-601A waiver, who should file an I-601A waiver, and what type of evidence do you actually need for an I-601A waiver. I am U.S. Immigration Attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The I-601A waiver is an inadmissibility waiver. It's for people that are considered inadmissible due to unlawful presence in the U.S. Basically, unlawful presence in the U.S. means you are in the U.S. outside of a legal status. So either you entered the U.S. with a visa and then that visa expired. Once it expires, you are accruing, you are adding up unlawful presence, or you entered the U.S. without any sort of documentation, you are also immediately accruing unlawful presence. So that's what this waiver does. It waives the fact that you are in the U.S. unlawfully. In order to qualify for an I-601A waiver, you must have a qualifying relative that will suffer extreme hardship if you were not allowed to remain in the U.S. or if they have to leave the U.S. with you. Now let's start with who is a qualifying relative. A qualifying relative is a U.S. citizen or permanent resident, spouse, or parent. That's it. Either you have a U.S. citizen or permanent resident spouse, or you have a U.S. citizen or permanent resident parent, or both, right? But no one else qualifies as a qualifying relative under the I-601A waiver. So if you have children that are U.S. citizens, they would not be a qualifying relative for an I-601A waiver, even if you are their sole caregiver. This waiver is strictly limiting who is a qualifying relative. The second part of that is extreme hardship, right? So it is not just what happens when you are separated from your spouse, what happens when you're separated from your parent. You need to show that that parent, that spouse, will suffer extreme hardship, something beyond the ordinary. Simple separation will not be enough. In the third part, I'm going to talk about the evidence you can use to show this extreme hardship. Now, who should be filing an I-601A waiver? The I-601A waiver, like I said, only waives unlawful presence. So if the only thing you have against you being able to get your immigrant visa to the U.S. is the fact that you have unlawful presence in the U.S., then the I-601A waiver, if you have a qualifying relative, is most likely the best route for you. If you have any other negative immigration history, criminal records that will affect your inadmissibility into the U.S., then you need to make sure that you are looking at the full picture to make sure that the 601A waiver is even an option that will help you. So for example, if you entered the U.S. without inspection, you have unlawful presence. But while you were in the U.S., you had a conviction that makes you inadmissible. Let's say, for example, you had a marijuana conviction and you have that on your record. Now, would the 601A waiver work for you? Not really, because when you go out of the U.S. to go to that embassy interview, the 601A waiver will only cover the unlawful presence. It would not cover that marijuana conviction because you need a separate waiver for the marijuana conviction, okay? You need an I-601 waiver. And depending on how much you had on you, if you had under 30 grams of marijuana possession conviction, then you may qualify for a 601 waiver. But when it comes to that 601A waiver, it will only waive the unlawful presence. You go to your interview, the office is going to see that you had that conviction and still deny you the visa, because the 601A waiver does not cover anything other than unlawful presence. So if you had misrepresentation, this does not cover it. Okay. If you presented fake documents, this does not cover it. So it's really important that you are looking at the right waiver and having the right strategy. You want to make sure that when you get to your visa interview, you are actually going to be approved, especially if you go through the trouble of applying for an I-601A waiver. So just to recap, in order to qualify for this, you need to have unlawful presence in the US, and that needs to be the only thing that stops you from getting a visa to the US. You either entered without inspection, or you entered with a visa, but you overstayed that visa, and you are not an immediate relative of a US citizen. So that requires you to leave the US, go to an interview at an embassy outside of the US, and get your visa to come back. Now, I'm going to pause here before we get to the third part of the evidence. I'm going to pause here and kind of talk about the mechanics of how this works, because sometimes people think you apply for it and then you leave the US immediately. No, please don't do that. Okay. So quick breakdown. You file for the I-130, the I-130 gets approved. Okay, you get the notification from the National Visa Center, you pay the visa fees, and then you file for the I-601A waiver. You wait for that waiver to be approved. And then once it's approved, you can go through the process with the National Visa Center to get your visa interview scheduled. Once it's scheduled, then you leave the US and complete the rest of the process. Remember, you do not leave the US without your I-601A waiver being approved. If you leave the US before it's approved, guess what happens? It doesn't count, okay? If you don't wait for it to be approved and you leave the US, it no longer counts. So now you'll be in a situation where you're outside of the US and now have to go through a different process and a different waiver in order to be able to come back. Okay, that means more time that you're spending outside of the US away from your family. So that's why I wanted to go over the mechanics of the timeline of how this actually works. So I-130, wait for that to be approved. National Visa Center, pay the fees, file the I-601A waiver, wait for that to be approved. Then you can leave the US for your visa interview once it's scheduled. All right. Now, let's get to the part that you really wanted to know about, right? The evidence. The evidence is the key to an I-601A waiver. So, like I said, for the 601A waiver, you need to show that there's going to be extreme hardship to a qualifying relative. So, how do you show extreme hardship? Medical, right? Medical is number one. All right. I have had cases where we won the I-601 just off of medical. If there are serious medical conditions that require treatment in the US and that person is not able to get that treatment outside of the US, or it's not equivalent to the treatment they will get in the US. And if that treatment is not equivalent to the treatment they're going to get in the US, that is a great thing to show for the I-601A waiver. So if you're going to lean into the medical, you want to make sure that you're providing medical records. And when I say medical, I mean your physical health and also your mental health, okay? We are looking at the whole person, not just physical ailments. We're also talking about mental health here, because there are countries that do not have a mental health system that can provide the medication that the person is on, that can provide ongoing counseling and treatment. It's just not a thing in some countries. So it's really important that you are not just focusing on the physical health of the person, but also the mental health of the person. Now, if the person applying for the waiver is the caregiver to the person that has the medical issues, then that's even a greater thing to provide, because that's going to show that this U.S. citizen or permanent resident qualifying relative is going to suffer even more if their spouse is not allowed to stay in the U.S., because they're so reliant on that person to make sure that they are getting the medical care they need, to make sure that they're taking their medication. All those things matter. Okay, so you want to document that. Next is financial hardship. If the person applying for the waiver is the breadwinner in the family, they're the ones paying for the mortgage, the rent, the everything, you want to document that as well. Because if the qualifying relative is going to have a hard life in the US without this person, that hardship in combination with, let's say, the medical hardship is what's going to make a difference. So you want to look at every single aspect of that person's life and look at how is this person that is going to be applying for this waiver essential in the qualifying relative's life. Okay, so that's, again, medical, financial, emotional, all the things. You want to include every single thing you can think of, because USCIS is going to look at the full picture. So if you only send medical, they're only going to look at the medical. But if you send the medical and then also say there's a financial aspect, there's an emotional aspect, the officer now has a full picture of the person's life and can make a decision based on that full picture. As I said before, the children are not qualifying relatives. However, the parent can still be affected by what happens to their children. So you can still include evidence of hardship to the children, but in the context of the parents. All right? In the context of the parents. So for example, if, let's say, the qualifying relative has a child, but the child's other parents will not be willing to sign the paperwork for them to take the child with them outside of the US, that's a hardship, because now that parent has to choose between their spouse and their child, right? It's either they stay in the US with their child or they leave with their spouse, knowing fully well that they're not going to get the paperwork necessary to bring their child with them. So yes, that's a hardship to the parent. Another way to look at hardship to the child affecting the parent is, let's say the child has mental health issues and they are getting counseling, they are doing better, and now there's a consideration of leaving the US and what that will actually do to the children. Also, if the children stay with that parent and the other parent has to leave the US, what would that do to that child's mental health? And how would that then affect the qualifying relative parent? Okay. So it is a mixture of everything. You want to look at the full scope. So when children are involved, we're looking at their education. Are they going to be able to get the same type of education outside of the US? Are they going to get the same medical treatment outside of the US? Are they going to be able to have the same quality of life outside of the US? And then conversely, are they going to have the same quality of life in the US without their other parent being allowed to stay in the US? So you want to kind of look at both sides. What happens if the qualifying relative stays in the US and the applicant leaves? And what happens if the qualifying relative leaves with the applicant? You want to look at both sides and present evidence on both sides. USCIS can approve it based on if one argument is stronger than the other. USCIS can approve it based on which argument is stronger. Okay, they can still approve it. So make sure you're making arguments on both sides if there's arguments to be made on both sides. So, quick rundown of types of evidence to include. You want to include medical history. You want to include tax returns, pay stub, things that show the financial capability of the applicant. If you do not have strong financial or strong medical, you may want to look at getting a psychological evaluation from a licensed mental health professional that can actually do a full evaluation of the qualifying relative to see what are the effects that will happen if their relative was forced to leave the US. Okay, sometimes what I find is that when we're talking about how things are going to affect us, we're not able to actually diagnose what that feeling is, but a professional that is licensed to recognize those feelings can actually say, you know what, you're telling me about your history, that's actually depression. And if your relative leaves and you already had depression in the past because of someone leaving, that is going to make your depression worse and or recur. So it's really important to also think about it in that way to see if a psychological evaluation would be helpful in your case. I do not recommend it in every single case. I will say that. I have had successes with clients that never had to do a psychological evaluation because we just had so much other evidence to include that the psychological evaluation was not necessary. Okay? But that is a decision that you should be making with your attorney to determine what type of evidence would be best in your situation. If you have any questions about the I-601A waiver, please feel free to put them in the comments. If you're listening to this and you're like, oh, I need help reviewing my I-601A waiver packet, I need help preparing my I-601A waiver packet, or I need you to represent me in my I-601A case, feel free to reach out. You can go to my website, lilylegal.com, click on contact us, and you can pick a date and time that works for you for us to talk about your case, figure out what the best option for you is, and make sure that you are putting your best foot forward when it comes to this waiver.